So just fair warning to everybody, we are recording this meeting. We're recording it because we've had a few requests from individuals who are unable to attend, and we want to be able to post this to the website afterwards. So it will be posted on our CEMA YouTube account, just so you all know. Anyone can unmute themselves if you like. Our general code of conduct is please send questions via chat to everyone so that we can respond. And if there's something that's super private, then go ahead and send it just to one of us privately. But we do want to be able to answer everybody's questions. So we're trying to respond to questions publicly, and that really helps out if they're posted. Why don't we go ahead and introduce your CAC, which participated in these negotiations. My name is Zeb Feldman, CEMA OE3 business rep. And Alex, why don't you introduce yourself?
Alex Searle, I'm a staff attorney in my office here at HOJ.
And Steve?
I'm Steve Gall, I work in ISB.
And Georgia?
I'm Georgia Koo, I'm working court facilities.
And Laura Romero?
I'm Laura Romero, I'm a staff attorney at the South Health Center.
And also on the executive board for CEMA?
Yep. Mm-hmm.
And Ravi?
Hi, I'm Ravi Ganchi. I'm from IT.
Okay, and I do not know, Dimitra, if you're joining us on one of the phone lines, but Dimitra Alvarez was also there. If you are present, Dimitra, go ahead and unmute yourself and introduce yourself. Okay, looks like she is not around, but Dimitra was also present in the negotiations. I believe was there for all of them. So she just is unable to join us today, unfortunately. Okay, I already see a chat coming. Oh, someone's just testing. Thank you, Frank.
Okay.
Feel free to test. The chat's enabled. As I mentioned, you can unmute yourselves. If we do climb above 50 people, what our regular convention has been in this COVID time is then we turn off the ability of people to unmute themselves and we start moving to a more, you announce and chat. I don't think we'll have to do that with this group. The court has historically been very well conducted, but sometimes when you get a lot of riotous social workers or nurses on the case, you gotta hit that mute button. So what I'm gonna do is make use amply of chat here as well. So I wanna put into chat the agreement. You've already seen this agreement. It was emailed out, but I do wanna make sure that everyone is able to review it on the spot. So I'm gonna put that in chat right now, and you'll see it appear in chat. Let me just put it in there. Hang on one second. All right. And then you can download it as well. So that should appear for you in chat. And we have mocked up a frequently asked questions. So I will likely share my screen in a short while, and we can go through the different questions that were frequently asked. And then we can also field questions from you all. So before I hop into this, anyone of the CAC, do you want to talk a little bit about the bargaining process and maybe how we got here?
I can say a few words. So we have a contract. It's the MOU, and that's what we bargained a year and a half ago. Okay. And I'm sorry, I'm not even showing I turned my video on, but my laptop is closed. How callous is that? It's terrible. All right, here I am. It's worth noting that the court was not obligated and did not want to open our contract and modify our contract directly. So that was off the table. Instead, what we did was we negotiated an agreement which will become a side letter to the contract, like we have other side letters like telework and things like that, or have had in the past. This side letter is contract language. It's just not within the contract. It works just the same. Typically, you would bargain something like this as kind of like a side or outside case, or time-sensitive case or something like that. So in this case, it's really covering the next fiscal year. At the end of this next fiscal year, it sunsets, it ends, and then who knows where we'll be, and maybe we'll all get together again and do another side letter for the next fiscal year. So what we have in place just covers July 1st to June 30th, 2021. so for the purposes of the side letter, the bargaining process was the same. It was interest-based bargaining or hybrid approach. We, introduce, instead of introducing a whole mess of stuff, the whole constellation of things, we make a proposal with individual items in it, and then the court returns with a counter, maybe takes some out, changes some, maybe adds some more in, and we kind of go back and forth until we have the agreement. I believe we met, I want to say 10 or 12 times, or quite a few.
Yeah.
Shorter sessions, but maybe 2-3 hours instead of all day. In my opinion, I've never seen the court in 10 years. I've never seen the court move this fast on anything. They were extremely motivated to get a deal. It's also worth noting that they were not obligated to bargain with us.
That's right.
So let's say before bargaining started, they got hit with a budget shortfall of 13 million. The only thing they are contractually, or they can do contractually, is lay people off. And it's also worth noting that other courts in the state took that route. They just said, well, our contract says we can lay people off, so here we go, 13% layoff across the board, or whatever. Sacramento court did that. I think San Mateo court did that. So I think in my opinion, it expresses, I think credit should be given to the court for wanting to bargain and not just wanting to lay people off. And of course, as union members, SEIU, CEMA, however, I mean, we all think the same. We don't want to harm our members by laying people off. That's the last thing we want to do, because that's just, it's a terrible thing, and also a terrible thing during this terrible time. So we were more than happy to bargain, and I think as we go through the document, you'll see that we put as many, we gave some furlough days, but we also worked up kind of a comprehensive set of incentive programs that we could help save the amount of money, the percentage of the money associated with our unit, which is around 30% of the shortfall. And that if we did, A, layoffs go away for the rest of the fiscal year, and B, we start cutting into our furloughs that we gave. And the ideal for CEMA, and I'm just talking with CEMA because we're just CEMA now, the other units, whatever they bargain, they'll have to work that out. But SEIU, their agreement is the same as ours. Skippy, unfortunately, is refusing to bargain, which is not going to go well for them, I think, because they'll just get laid off. But so if we achieve, these tiers of savings, and if we can recoup all of the budget shortfall for CEMA, then our furloughs get paid back and end. Well, they end, and then they get, the ones that we took get paid back to us. So, I think we tried to make the best of, a really bad shortfall. I think what we've come up with is pretty comprehensive. I think it gives some options for some folks. It puts some money in your pocket going out if you want. We also, well, I don't want to go through the whole agreement, but anyway, and we'll talk through it. But I think it's a fantastic deal, and I think it's also worth noting. And I don't know the reason or the law or the structure of it, but this is an agreement that basically the two business reps, or the lawyer for the court and Zeb being our authorized business rep, are authorized to sign and make it a reality. That this is not something that we had to take to the membership for a vote. And I'm not arguing whether that's good or bad. I'm just saying that I guess that's how a side letter goes, and Zeb can tell me why that is. But
sure. And so thank you for that brief history. Also, if any other member of the CAC wants to chime in, please do. Also, this is, I think, the first time that we've successfully negotiated with the court in a coalition. We were with SEIU and not truly court interpreters. They participated more as an observer because they bargained with the court in a regional way, but they were certainly present. And we wanted to include SCPEA or Skippy in our coalition. At the last moment, they bowed out. But we really took a leadership role in that coalition as well. And I think we got a very good result. So to address what Steve said is why a vote is not necessary as it is with a contract is because this is an enhancement of the contract language and it is not compelling anyone to participate in it. So you are able to choose. I mean, you could opt to be laid off if that's what you wanted for whatever reason. If you don't want to take advantage of the VSIP or the long-term leave or the voluntary reduced work hours, you are not obliged to. What you are obliged to take part in is the furlough unless we meet specific targets. We did send out the bargaining survey so that we were able to prioritize things that we believe you all wanted or you expressed to us that we wanted. We had a good survey population. I believe about 75 people filled out the survey, mid-70s, filled out the survey out of an eligible population of approximately 110. So it was a very good response. If the number of people who participate in the VSIP or golden handshake, however we want to characterize that, actually materializes based on survey results, then we will be extremely close, if not exceed the layoff protection for sure, but we may even get substantial furlough reduction as well. So broadly speaking, I think you all can read the agreement. What we're pleased to present and announce is, as Steve pointed out, all that the court owes us with our MOU is a 20-day notification that they're planning on laying people off. And then we implement the layoff language in the contract. Instead of that, we've achieved layoff protection for the first 10 pay periods, possibly for the entire fiscal year, depending on what savings we achieve. We've achieved I believe, a generous financial package for people who are close to retirement. And even one individual has pre-announced, I don't know if you're on the call or not, you don't need to identify yourself, but one individual pre-announced that they were planning on retiring. They will be able to take advantage of the VSIP. And anyone who chooses to retire in relatively short order will also take advantage of VSIP. So some key, actually, the Q&A, I think, will answer a lot of questions. So unless there's a burning question on someone's mind or something that someone on the CAC wants to introduce, I'd like to share my screen and go through the frequently asked questions, and then we can open it up to general questions. Is there anything anybody wanted to add prior to hopping into that? Okay, seeing nothing.
Can they email that document out? Because not all of us are on Zoom.
Yes. Hang on one second. Sorry, my dogs are going nuts here. Yes, can I ask, this was sent to the entire CAC. Can I ask one of the CAC people to email it? I don't know that we have a comprehensive list in the snap of the fingers. So I'm not sure what the easiest way to handle that is if you're not on Zoom. I'm looking to the CAC for ideas here.
Well,
I think once we done consolidating, we're going to share the document, all the question and QA, so everyone will have it.
Okay, and this review will also be posted to the YouTube channel this evening, and then for advertisement tomorrow. So you will certainly be able to review it for anyone who needs to.
So also, I just want to say for those for those CEMA members who, for whatever reason, have not been getting regular CEMA emails or notifications, please let me know. There's like a handful of you guys that I know. Just let me know. I'm Georgia, and I can email the final documentations to you as well if you're not on Zoom, on video Zoom, that is.
Great. Thank you for that, Georgia. So here, displayed on my screen, I'll read them because a lot of people are on, or not a lot, a few, maybe 5 or 10 people are on telephones and maybe can't see. The share screen is working. Someone on the CAC nod. Yeah, okay, thank you, Georgia. Okay, so here are some questions. These are based on email questions that we have received since this was noticed on Friday. Furlough question. Do layoffs must happen by fiscal year pay period 10? I think they just mean must happen. Do layoffs happen fiscal year pay period? So here's the answer. No, but this is the earliest the court could implement. We have a 20-day calendar notice period. So our general agreement still stands. All terms and conditions of that stand. So if the court wanted to lay people off by pay period 10 in the upcoming fiscal year, they could, if we did not achieve full layoff protection, which we can get to in a little bit, or and they also would have had to give us 20-day calendar notice prior to pay period 10. And by us, I mean not only the institutional union, but you specifically as an employee are also entitled to notice. So this will not come as a surprise to anyone. It's our belief on the basis of people who indicated that they wanted to retire that this will not be an issue. But to answer the question, it is a possibility. Furlough question. Will furlough hours show up in Phoenix? Unknown. The court administers this. However, they did state that it would show up in Phoenix. I simply can't imagine another way to implement this without having a furlough bank established. In years past, when the county implemented furlough banks, they created a separate bank. You drew down the furloughs just like you would vacation and then would consume them completely. VSIP, or Voluntary Separation Incentive Program. Must one use management leave and COVID administrative leave accrual hours prior to September 1st? So I'm guessing that whoever asked this question is using the September 1st time because they're anticipating retiring in September 1st or separating from the court. So yes, if that's the date that you're intending to separate, you do want to use those prior. However, here's the official answer. No, these leaves have differing sunsets. So COVID goes out for a long time. I think it's 3 years that you have to use it. And management leave is based on the fiscal year. So the only reason you would have to use these leaves prior, and you don't have to, but if you want to maximize your leave usage because you're planning on separating from the court, then you would want to use those prior to September 1st. If you're not planning on retiring from the court, then there's no reason to use anything prior to September 1st, unless you just want to. So I hope that answers that question. VSIP, what is considered a work unit? This is a term of art that I suspect we will likely be arguing about, but we at the table were viewing different areas as functional areas as work units. For example, facilities, self-help center, family court services, ISB, etc. There are some areas that are probably gray. For example, I don't know if you're on the call, Tom, but the law library. Okay, is that a unit or is that part of a broader unit? Unknown. We would have to have that discussion, but certainly like ISB is a work unit, right? So there are some areas that self-help center is a work unit. There's some areas that are very, very clear. There are much smaller areas or assignments that would probably warrant some discussion. VSIP question. If one work unit has no applicants, can the slots available be made to the larger pool? So yes, it can be made available, but there is no requirement. For that matter, the court may well approve VSIPs far in excess of 15% rounded up. So the 15% number or figure was inserted at the insistence of the court because there are some areas where they do not want to accommodate much more than a 15% gap, if you will, because people are retiring or choosing to separate from the court. If, however, they could well grant 50% of a unit or 100% of a unit if they want to fold that, it's a small unit and they want to fold those responsibilities or duties into a different operational unit. So it can happen, but there's not a requirement for it to happen is the cleanest way I can think of to answer that. VSIP number 6. If the court rejects an application, is the only item refused the financial incentive? Does the court also reject the retirement dates and how accruals were used? I'm not quite sure what the accruals were used question means. So maybe if the person who asked this wants to clarify, but no, the court may only reject the financial incentive piece and possibly accrual usage. It may not prevent you from retiring. So you get to retire, separate from the court when you want. If you are in excess of the 15% and they want to deny you access to the VSIP plan for whatever reason, they're incentivized to include you in it because they don't know for sure that you'll be retiring if you don't have access to it. Anyone who announces their retirement as a result of this, the assumption of the court is going to be that you are choosing to retire because of the incentive, not just because you decided to retire at this particular moment. So no, they can't reject it. As far as accruals were used, I suspect you're asking, can you get your vacation or management leave or whatever approved prior to your retirement? That always rests with the court as to whether or not they would approve that. They have to cash you out at face value for STO, but they don't have to cash you out at face value for management leave or COVID related leaves. So obviously you'd want to use those first, but they don't have to approve it instantly. Okay, let's see here. 7, long-term leave of absence question. During the long-term leave of absence, does the coverage include dental and vision? Yes, we contemplated full medical and costed it out as such. So if you look at the costing, that's it. Did we, I don't know if we specifically discussed this with the court. Ravi or Steve, Laura, do you remember specifically discussing this?
No, not about the dental, but we have discussed on the whole of medical coverage.
Okay. And I would certainly expect it to be. I believe we're on solid footing with the contract
I agree.
language and especially the costing. Sorry, go ahead.
I agree because they mentioned all the other things they're not paying, and vision and dental was not one of the things they're not paying. So it looks like they clumped that in with medical.
I agree with that. Thank you. Okay, 8. What is the latest day I can retire to take advantage of the buyout? There's a parenthetical, July 15th. I think part of that got cut off. So the contract says you must apply for VSIP by 7/15. However, this is an earlier attempt that says, as far as I know, court has not specified a formal separation date. In fact, it has, as I've reread this section, it says you must notice the court by July 15th and you may leave no later than October 2nd. So there are sort of two variables here. If you don't use any STO, you have to separate by September 1. If you do use some of your vacation time, you can separate as late as October 2nd. But I don't believe there's any opportunity to leave later than October 2nd and still qualify for and use the VSIP cash that you get. Which I mean, I realize we haven't talked about this, but as a reminder, the VSIP cash is a lump sum of $15,000 with, I want to say we ended up at 1,500. Is that correct, everybody?
Yes, 1,500.
Yeah. And 1,500 per year of service with no maximum. There was previously a maximum that the court wanted. So we negotiated them up a lot. They started out at 10 and 1, a 10,000 lump sum and 1,000 per year with a 30-year cap. We
started at 750 a year.
Oh, it was 750? Oh, I apologize. I'm giving the court too much credit then. Okay. So yeah, this right here is the timelines. July 15th, and if you have STO to use, you can separate as late as October 2nd.
Let me just clarify that. So that means that your last day is September 1st. So you should be gone and have your desk and possessions gone by September 1st, but you're just on the books running out some vacation time until October 2nd. That's my understanding.
Yes, and that's accurate, Alex. The court can allow you extra time to vacate if that's an issue, as they will. But you're right that you are not working, you're consuming STO time absent from the workplace. And the benefit to you is that the reason why you might want to do that is because you are building your PERS possibly for another quarter, if that's something that you're interested in. We believe that it's a pro rata adjustment for your pension calculation, but there was a question as to whether or not it was. So if you believe otherwise, you can write it out to the next quarter. How long do health benefits for my spouse last? What is the exact date they would stop? Great question. I'm not 100% on this. Oh, sorry, this was an earlier answer. Okay, they would end the final pay period of employment. So the pay period of October 2nd, whatever pay period encompasses that, 2020, if you separate it at the latest possible time. Otherwise, if you separated September 1, it would go through the remainder of that pay period. Most employers tend to round out the month. So you could well get the entire month of September if that's been the court past practice, but I do not believe they are obligated to give you the full month. But the coverage for your spouse ends at the same time that coverage for you does. And for that matter, for your children, if you're on a family plan. Would I receive the 4/2020 personal days? I believe this is a reference to the management leave. No, these are not like sick or vacation accruals. It's a use it or lose it every year. So I'm assuming this person is asking if they separate, but it's not really stated. If they separate on September 1, yes, you would get the management leave days, but you would have to use them very quickly if your manager was able to approve them, but you would not get them cashed out. So I hope that's a comprehensive answer to that question. I'm not quite sure what's being asked there. What happens to my COVID-19 accumulated hours? Again, I believe this is asking if they retire, if you retire. It's just like administrative leave. They can't be cashed out, but they could possibly be used if you're able to, schedule some administrative leave time prior to your separation from the court. If you're not separated from the court, none of your personal management leave days or COVID-19 days are impacted by anything in this agreement. If you're not separated, you continue to use those as normal. Do you know what is happening with our raises that we were supposed to get in August? They're still part of the contract. All raises for the years of the contract that are remaining continue to fire in the summer, and you get that at the 3% as planned. Can we use our leave accruals pay on our chosen furlough days? No. The goal is so the court can save money. Using accruals would not accomplish that. So it's not possible to use sick or STO management leave, admin leave on days that you would be otherwise on furlough. 14, I was hoping to get some clarification on the VSIP. In October, I'll be 51. If I opted for this program, would I be able to hold off on notifying CalPERS until I turn 55? And once 55, would I still receive the 2.5 times my highest earning year? So this is a complex question. Whenever I answer questions concerning CalPERS, for those of you that work with me with any length of time, you always know that I say asterisk, asterisk, you have to contact CalPERS. They're the final arbiter of this. However, the answer is yes. Which is that you can wait. You need to fill everything out, right? And I would even call and consult with CalPERS and say, this is my plan. CalPERS cares about when you begin collecting your benefit. As long as you have vested, and that's another key, you have to have vested. If you have vested in CalPERS, then you could wait. And this is a great example. The individual in this question is 51. They're saying, I want to wait until I'm 55 to collect my benefit, so I get the 2.5% pension formula. Just as a quick reminder, for if you retire at 55, you're eligible for 2.5% per year of service. So for nice round numbers, if you worked for 10 years, 10 times 2.5 is 25%. You get 25% of your highest year of salary if you're a classic employee. Well, you'd have to be a classic employee. If you're a classic employee. So, and then you get the 2.5%. So let me just read the response. Yes, CalPERS uses the formula not at the time you retired, but when you begin collecting the retirement benefit. The small bit more you get by waiting to go from 2.02% to 2.5% is offset by the 4 years you're getting zero when you could at least be getting your pension calculation at 2%. But the bigger issue, and this is a significant one, is that if you take VSIP but do not also retire at the same time, you will lose the retiree health coverage. Retiree health coverage is an enormous value, and you will be far behind overall if you give that up for nothing. So perhaps this person has an unusual circumstance where perhaps they get retiree health coverage through their spouse. Maybe they have a sideline that they can start, building up a different pension in. You know, they go work for the city of San Jose. Well, I don't know why you'd want to, but let's say you did. They have a separate pension plan that is not CalPERS reciprocal. So you can build that pension in addition to your court pension, as an example. Everybody has to game it out. I would really recommend gaming it out and using the lower pension, in this case, 2%, figuring out what that's worth for 4 years, what the loss of the retirement medical is to you, if that's helpful to you, and see whether it helps your finances to wait to the 2.5 or not. For some people, it makes sense. For most people, it really doesn't, unless you're planning to live to be like 150 or something. Like it does, and then you get that 2.5%. So it's just a numbers game. You do the math. Let's say you think you're going to live to be 80. You game it out. What do I get from now until 80 at 2%? What do I get from 55 until 80 at 2.5%? And who can tell how long anybody's going to live, right? So it's kind of a roll of the dice.
Hey, Zeb, I've actually done extensive math on this because I wanted to know, and just to keep it simple, looking at the difference of going out at 50 versus 55. I haven't done the math for 51, but it's probably very similar. And the thing is, you know, the argument is, you know, you go out at 50. Let's say your pension, just to keep it simple, is $10,000 a year.
Yeah.
Right. So between 50 and 55, you're going to be $50,000 ahead of where you would be on day one at 55. Let's say then that at 55, with the increase in that 0.5%, you're now at $11,000. So now how long would you have to collect your pension to make the deal at 50 a worse deal, right?
Mm-hmm.
There's between 23 and 24 years. So if you think you're gonna, like Zeb said, if you're gonna last till 100, yeah, wait till 55. If you think, yeah, probably, you know, late 70s, 80s, mid 80s, or something like that, you may want to think about it because it's going to take you between 23 and 24 years just to make up the difference of what you would collect day one at 50.
That's right.
Yeah. Hopefully
That's
that
right.
makes sense.
Yeah, and I really would recommend you to game it out. It probably doesn't make sense for you to do. Again, individual, your mileage may vary, right? You got to calculate it out for yourself. If you are able to perhaps go to another employer that is CalPERS reciprocal, then it totally makes sense to not retire, or it may make sense to not retire from the court. It again is of enormous value to have the retiree medical as well. So that's a huge value. It really just depends on personal circumstance. If you have dual citizenship and you're moving to Canada, who cares? You've got universal health care up there. You don't benefit from the retiree medical. Take advantage of the stipend, maybe, so game it out. It's very difficult to imagine a circumstance where you would be better off waiting until 55, but maybe it works for you. It's super hard to imagine that circumstance, though. I believe that brings us to the end of the FAQs. Yeah. Have any of you gotten some emails since we developed this this morning or this afternoon that warrant addressing now? I'm going to stop the screen share, or else we can answer general questions.
Zeb, we do have some questions on the chat that I'm seeing.
Oh, yep. I see some coming in. Thank you. Wow, we got a lot. Okay. Estrella asks, does the long-term leave of absence have to be the full remaining fiscal year? Can you do 6 months? I believe the answer to that is no. It has to be the entire, in fact, I know the answer is no. No, it has to be the entire fiscal year. We talked initially in an earlier proposal, we talked about a 6, 12, and 18-month option for the long-term leave of absence, and the court said we're not interested in that. We're interested in knowing what our savings are going to be with certainty for this fiscal year, and they responded with a balance of the fiscal year. So it's not even a full 12 months. It's the balance of the fiscal year. So I hope that answers that question. Steve, to everyone. Oh, you already answered that. Thanks, Steve. So,
One more thing to follow up. I do say you can do so in 6 months if you wanted to. So if you were an edge case where, you say, hey, I'm going to go out for the rest of the fiscal year, but then that 6 months got you to your finish line, whatever that is, 50, 51, 52, 53 and a half, then just as the court could lay you off if it came to that, you could just retire from the court before the fiscal year's end, right? You're not obligated to do the entire fiscal year if you want to retire or separate.
that's right. No, that's right. Okay, someone messaged this to me privately. I'm not going to reveal who it was, but they say, will the 3% be based on our pay now, or will it be at a minus 10%? So it's a good question. It will be based on your pay now, but then it will be reduced by 10%. So for example, if you make $100,000 a year right now, the 3% raise fires, and you then make $103,000 a year. However, the furlough, if fully implemented, which we don't believe it will be, but let's pretend it is fully implemented, then you get a minus 10% on the $103,000. But you get the raise on your base salary. The furloughs do not change your classification salaries or the step system. Just so hopefully that's clear for everybody.
I think it depends too. I think the answer is it depends. It depends when you're planning to go out. So if you were planning to go out in this next fiscal year, well, bummer, you're not going to be able to make more than you made this last fiscal year.
So this was not a question about retirement calculation. This was a question about this. This one was sent privately to me.
Oh.
This was, will the 3% raise be based on our pay now, or will it be calculated after the 10% furlough?
Oh, I'm sorry. I was trying to answer a one down the line here. My bad.
Yeah. So I'm just, see, and again, folks, this is why we want to try to, I'm just posting this in for everybody to see. But this is the question I was just responding to, which is going to be at the end of the chat chain now. So I got to scroll up. Just give me a second here. Okay. Aaron asks, will the scheduled raises be calculated off current salary? Oh, it's a similar question, or furlough salary. It will be answered off of current salary, be calculated off current salary, which Ravi already answered. Thank you, Ravi. Okay, George asks, what figure will CalPERS use for pensionable earnings for fiscal year 2021? Full salary without furlough, 100%, or adjusted salary with furlough, 90%? That's an excellent question, George. Did someone already answer this? No. Okay. They will be using the adjusted salary with furlough. So again, we believe that it will be something less than the full 26 pay periods after we achieve all the cost savings, which is built into the agreement. But assuming we don't get any furlough reductions, then your example is correct. It would be at a 90% level. So in my earlier example, let's pretend you're at $100,000 a year. This year would be tabulated by CalPERS at a 90% level, $90,000. So you would want to use the prior year as your last year if you were planning on going out, right? And if you were, I mean, I don't know why you would plan on going out. If you're that close to retirement, then you should probably take advantage of the VSIP. But if for whatever reason you're not, and you want to work another year, then you would be at 10% reduction for that year. It also, CAC, if you want to answer any of these, just hop in. I'm not trying to hog the mic here. So
yeah.
One of the reason some people may not be able to go out now could be that they're not fully qualified for retiree medical. So that could be one of the problems.
Totally legitimate. They may not be vested in pension, or they may not be vested in retiree medical. Absolutely. Good point.
Yeah, and the reason why I was saying it depends when you want to go out. If you're looking to go out in 4 years, that will probably work, because hopefully we'll get past this and you'll get your salary back up again, unfurloughed salary, right? The CalPERS takes your highest consecutive 12-month earnings. Doesn't have to be fiscal, doesn't have to be calendar. It's just the last. So what I'm saying is, like I said before, if you're looking to go out this year, they're going to take this last fiscal year because you're not going to be able to make that up for a while. You're not going to be able to make more salary until we get off furloughs and we get through 21, 22, whatever that's going to mean. You know, maybe it'll take 3 or 4 years to get you up over this last period with that 3% raise.
Correct. Correct. Okay, Brittany asks, if you choose to take furlough days for a full pay period, is there any impact on health benefits? I previously was told you need to work each pay period in order to keep your benefits. No, there is not. So a feature of this is because of the smoothing, the furlough bank is, you're still getting paid. You're still a full-time court employee or a 90% time court employee whilst taking any leave that's related to furlough. So you would continue to get a paycheck. That's a benefit of us smoothing it. This can run into trouble if we structured it that you were totally unpaid, which is one of the reasons that we wanted to smooth it, so that you wouldn't have no income coming in. You would continue to keep your health benefits. Josh asks, can you explain, and again, CAC, if you want to answer any of these questions, just butt in. Can you explain how the bumping rights work? I understand the seniority part of it, but for example, I am the lowest CEMA member, legal process supervisor. I am designated to be laid off. Lowest seniority, I assume you mean, Josh. I'm designated to be laid off. Do I get to bump down to my previous position in Scipia, or am I just laid off? Also, am I still employed with the court? Also, if I'm still employed with the court and our budget is better and the court rehires for my position, would I get back, or would I have to reapply through the normal? Great question. Okay, so there's a specific order of layoff. It goes extra help employees, probationary employees, non-probationary employees based on seniority order. So in your example, Josh, you're presupposing that you're the one, that you've already dealt with the probationary, the extra help, and you're the lowest seniority person, and you're the one that's getting cut. So here's what happens first. You are able to in place, if there is a vacancy in the court that you wish to in place into, or the court wants to in place you into. So that's number one. You would do that because it's a higher salary and you wouldn't have to go to the Skippy position. You have to meet the minimum qualifications of that position. That may well not be the case. There may well not be court positions available like that, but that's what happens first. Then, yes, you are able to claim any position, and to your question is, can you go into your previous Skippy position? Yes, but only if you attained permanent status in that position. So what that means, which will apply to almost everybody, it means that you have to have successfully completed probation in that position. If you didn't, for whatever bizarro reason, you have no rights to that position. If you did, then even though you're a CEMA member, you can claim a Skippy position because you previously held that classification. You have employment rights to that classification. Let me see if there's anything else here. Oh, if I'm still employed with the court and our budget is better and the court rehires for my position, would I get it back or would I have to reapply? So you stay on what's called a rehire list for 24 months, and that's spelled out in our contract, or 2 years. And that applies whether you're a court employee or not. So let's just say you're totally laid off and there's no position for you to go into because you held the Skippy position for the mimeograph operator that doesn't exist anymore, right? That went the way of the dodo. So there's no position for you to claim. You can't in place anywhere. You're at home collecting unemployment insurance. You are on a reemployment list in both circumstances for 2 years. So if the court ever rehires for your position, you're first in the door. You don't have to interview for it. You're like, hey, remember how you got rid of me? Give me that position. So you have employment rights to that position. I believe that answers your question there. Okay, Fariba asks, just to clarify, if I separate but do not retire, will my retiree health coverage whenever I elect? No, you give it up forever. You have to retire in CalPERS and from the court at the same time, and then both benefits fire at the time that you retire from the court. If you just leave the court but do not retire with CalPERS, the court will be all too happy to wash its hands of you and not give you your health retirement benefits that you've vested in, that you're entitled to. And I happen to know, for Eva, you've been here for long enough to have vested in that. Okay, I answered that one. Gina asks, if you choose to retire, do you still need to take the 26 furlough days? Absolutely not. If you choose to retire, you will not have to take the 26 furlough days. If you, in fact, it's on or before September 1, which you can push out as far as October 2nd. If you notice the court, pardon me, and retire right away, you may well not even experience 10% reduction. Well, no, you would already this pay period, I think. You would very briefly experience 10% reduction. So but you may not take any furlough days. You would not certainly not have to. So, and you're not like obligated, Gina, to serve 26 furlough days by any means. Are furlough days treated as vacation days in terms of having to submit for approval, and can they be rejected? Yes, you have to submit and they can be rejected. However, it's extremely frowned upon. You'll see that there's language in here that the court will compel you to take the furlough days if you haven't scheduled them by the end of pay period 13. I believe it's 13.
Help me out, folks. Is it 13? 13,
12.
I believe so.
Yeah, 13
12.
and 20. 12 and 20.
Thank you. 12 and 20. So they're building in a cushion to force the furlough days on people to use half of them, because we don't want to be in a situation where you end up at the end of the furloughs. It's like, oh man, I need to take 26 days off right now. It'd be a disaster operationally. So yes. And they can be rejected, but you'll see that the language, if you're a CEMA member that's approving other CEMA members for furlough days, you are strongly encouraged to do that, to approve them. And there's a recognition from the court and executive leadership that it means that services will be impacted. This is not going to be a service reduction free situation that we're in here, unfortunately. Oh, you got it. Of course, this is a private thanks to the CAC and everyone who helped negotiate this. So thank you, Alex, Georgia, Ravi, Steve, and Dimitra for negotiating this wonderful plan, according to this person who privately is texting me. Another private text, could you clarify the 10% reduction for the paycheck? I'm not sure I followed this. Could you clarify if the 10% reduction to the paycheck is in addition to the 13 furlough days? So I guess I'm confused by this because there's 26 furlough days. There are 26 furlough days that ought to be taken because you're paying for them with your 10% salary reduction. There should be 26 furlough days that you take throughout the year, again, assuming there are no furlough reductions achieved by cost savings. And you lose 10% of your pay because you're taking 26 days off. So you're buying those days. There's no additional reduction in addition to the furlough days. So you serve a furlough day and you've already paid for it. You're not also losing pay on top of the 10% reduction. I hope that answers that question. Feel free to text privately or publicly if it didn't. Can you go over the repayment clause in paragraph 10? How does smoothing interact with the changes in what 10% amounts to when the raises kick in? Okay, so let me look at 10. Clause in paragraph 10. So this is going to be for the payback, I believe. Okay, so this is item 10. Let me read it so everyone knows. I now know what this person is asking. Any employee who, sorry, who is this that's asking this? M, I don't know who M is. M, any employee who leaves court employment for any reason between June 29th, 2020 and June 14th, 2021, and has taken more furlough days than the amount of the smooth reduction in pay at time of separation agrees and shall pay back the difference from their final check, whether by foregoing an equivalent amount of unused accrual payouts or by deduction from salary. So what this is designed to capture is, because of the smoothing, we are paying for the 26 furlough days over the course of an entire year. But you get the 26 furlough days day one. So let's say from now, for some reason, from now for the next 26 work days, you're off. You're like, I'm on furlough, your boss approves it. And then on your 27th day, you alert the court that you're leaving, that you're retiring. Well, you've taken 26 days off, but that was supposed to be paid for over the remainder of the year, but you've only suffered a 10% loss, suffered, if you will, for 2 pay periods. So you've paid for 2 of the 26 days that you took. So the court is saying, okay, give me my check, right? I you took all these days. So that's what this is designed to protect the court from. The court wanted this language, and we also recognize that it's legitimate. We don't want people front loading everything and then walking out the door, and everyone else had to work extra hard to pick up the slack for that individual, and they just walked out the door with a big check. Okay. Are the savings that need to be made in the first 10 pay periods for CEMA only? So there have to be savings proportionate with the number. Yes, it's not court-wide. It's only applicable for CEMA. So you'll see, I believe it's 29 point something percent, as memory serves. 29.7, how's that for memory? 29.7% is the CEMA share of salary on the basis of our unit. So we have to hit our target, which is spelled out here. It's 29% of 12 million. So if we hit that target, we are shielded from layoff protection, and then more than that reduces our obligation for furloughs. So it doesn't matter if Skippy or SEIU or the court interpreters or the bailiffs, or they're not called bailiffs, deputies, make their percentages. If we hit our percentage, that's what shields us from layoffs. And then anything beyond that further reduces the furloughs that we have to suffer. So it's based on CEMA calculations. It's not based on other units. It's a great question, though. Jason, when do we have to start using furlough days? Is it flexible depending on supervisor approval, or we are expected to begin using them now? Again, there are set timelines. So I think we said pay period 10 and pay period 20 are when you need to be using them by. That's when your boss can just start assigning you furlough days. So I would recommend you start using them. You know, use them 1 a pay period, 2 a pay period. If you want to, now's not a particularly good time to use a whole bunch of vacation to go on vacation, to go somewhere. But maybe you have child, elder care, educational needs, whatever, or you're just burnt out. So you can use your time whenever you want. I would encourage you guys to start using it soon.
Can you clarify the payroll dates, because our payroll calendar is not the same as what you guys are referring to? Payroll
Sure.
10 ended in May.
I'm sorry, what ended in May?
The payroll period 10 was in May.
So this would be pay period 10 of fiscal year 2021. So yeah, so the upcoming pay period 10 is when you should use your furlough days by, not the one that just passed, or not just, that passed a long time ago.
So can we know those dates, because it doesn't match up with the payroll calendar that we use for our payroll?
Right, so what this person is saying is that we get a calendar year from January, so what he's looking at as far as 2020 pay period 10 is different than what we're saying is pay period 10 from fiscal year. So there's the difference.
So this in the agreement is spelled out. It's saying the pay period beginning November 30th, 2020. So what you're suggesting is that in fact is not pay period 12?
It's just different than the one we use for our payroll.
Huh.
Right, I think we can it's easier to go by date.
Okay.
Whatever date that they have, if it's November 30th, I think that's what we need to, the membership can follow that easier.
Okay. So that's good to know, though. I'm noting that on my copy here that for some reason our dates or the pay periods are off.
Actually, Estella has responded pay period 26 on payroll calendar.
Okay, thank you. Oh, does that clarify it?
Yes.
Okay, great. I think that answered Mr. Major's question, or Majors, sorry, I don't know. Brittany says, oops, sent too soon. So Skippy, SEIU, et cetera, cost caving. So SEIU isn't it. I'm not sure if I understand the question. We're in our own silo. We have our own target we have to hit, and we are rewarded for hitting our target. It doesn't matter if Skippy or SEIU meets their targets. We can achieve layoff protection independently. We can achieve furlough reductions independently of whether Skippy, SEIU, or the interpreters meet their targets. They have similar percentages, right? Based on their percent of payroll, that's how their savings will be determined. So I hope I'm answering that one, Brittany. Okay, great. Yeah, I'm glad we answered your question. That was a private message. M is saying thank you. It was unclear when we were paying for stuff. Okay, thank you, M. Brittany, looks like we answered your question. I have a private question asking, based on the web survey, CEMA will most likely meet our savings goal by employees taking advantage of the various options. Yes, that's based on our survey results. That most likely we will hit the layoff protection and some modest furlough reductions. I don't think complete furlough reductions based on the responses to the survey. But again, it's incomplete data. It's people saying, I think I would retire if there was a nice benefit. And yes, voluntary reduced work hours and long-term leave sound good to me. It's a very different thing when someone actually has to make that decision to leave or go on those leaves. But on the basis of the survey results, which again was not all of our membership, so we expect a few more people would probably take advantage of it, may well retire. But yes, in answer to your question, yes, that's our expectation, that we will at least achieve layoff protection and likely will achieve some significant furlough reductions as well.
So Zach, can you also get into a little bit on when we will know from the court whether CEMA has reached our quota based on the VSIP and furlough and I mean, not furlough, but VSIP and volunteer reduced work hours?
Yes, it's stipulated here when we re-meet to do that. I'm looking for it though. I don't know. I don't remember the exact. Here it is. It's pay period 9. And I know there's some discrepancy now with the pay periods. But so it would be probably in if November 30th is pay period 12, according to these numbers, pay period 9 would likely be mid-September. So mid-September is when we will actually be noticed what our credit is, because that's the deadline that people have to notice. Are you on VRWH? Are you on a long-term leave? Are you separating from the court? So that would be it. I've got 20 more questions here. So I'm going to try to go through them as quickly as possible. There is chatter that a golden handshake adding 2 years of survey credit was being discussed. Is this factual? If yes, is this on or off the table? It's off the table. It was being discussed. It required action from the Board of Supervisors at the county, which is in recess, and it involved too many moving parts and unknown variables. We wanted to be able to present the membership with a concrete package and not have people wait on an item that may not come through. The Board of Supervisors would have had to take action to authorize it. And there's significant worry from the Board of Supervisors that, I shouldn't say from the board, from county administration, that allowing some of its employees, for CalPERS purposes, you guys are impacted employees of the county because they administer your pension. The county is having its own budget woes to a much lower degree, and there were a lot of complexities. They were contemplating not offering it because they didn't want to harm their ability to offer golden handshakes down the road as well. So thank you for that question, George. No, it is not on the table, and no. Okay, already answered my question. Great. George is thanking Estrella for clarifying. Great. Gina, is it 1,500 based on your years with the court or CalPERS? It's based on your years of service with the court. It's not based on CalPERS. So if you've like bought airtime or something, and let's say you've worked for the court for 15 years, but you have 20 years because you served in the military or something and bought airtime or bought time at some point, you would not receive credit for 20 years of court employment. You would receive credit for whatever you actually worked at the court.
And one more question on that. If you are like at 28.9, are they going to consider it 28 years, or I doubt that they would round it up, correct?
CalPERS works on a quarter system, so they give you 28 years and 3 quarters credit.
But with the court, when it goes to the calculation for that additional 1,500 for each year?
It's a good question. I would hope they'd give it to you, but it's not. It doesn't say round it up, so I would count on them not. In terms of enforceability, I would count on them not.
Okay.
Thanks, Gina. Okay.
Oh, and there was a second part to that question too. With the paycheck, have they discussed whether it would be included into our normal paycheck, or would it be a separate check? Because I think that makes a difference if you want to roll it over to like deferred comp.
The mechanics is not negotiated. How they pay you is whatever their normal separation process is. So we didn't negotiate a special process for this.
Okay.
George says, the state SEIU union accepted a 10% furlough for 2 years. So my guess is that there's a high probability we will be dealing with another side letter in June 2021. That is a possibility. I think a lot of it depends on what the extent of the salary savings are and how many people retire. It's a real unknown. If a huge percentage of the membership, by huge, I mean, we have indications that somewhere in the neighborhood of 10 to 15% of the membership may retire. That's significant savings. If that much many people retire, we may not be having this conversation in 2021 or 21-22. If not, then we may. I really don't know, but it's good information, George. Some private questions here. Will we see a 10% reduction on our paychecks? Yes, you will see a 10% reduction regardless of if you take your furlough days. So think of it this way. You're buying extra vacation with a reduction of pay. So you might as well take your furlough days. What if all my supervisors request to use their furloughs around Christmas? I mean, so furloughs need to be scheduled similarly. It's not identically, but more leniently than vacation, but you can't have everyone taking your furlough days at the same time. You still have to be able to provide some services to the public. So this will be a challenge for some CEMA members. Okay, 2 more questions. Is the 1,500 only for consecutive years with the court or separate? For example, if I worked 2 years prior for court, left, came back for 2 more years, would that be 4 years credit for the calculation? Yes, it would be 4 years credit for the calculation, and also for that matter would be 4 years credit for your seniority as well. So yes, Jason. Julie, if you bought 5 years service credit, are those 5 years eligible for the 1,500 per year? They are not. Again, a military credit, if you bought airtime, let's say you may have even had CalPERS credit from a reciprocal agency, right? Let's say you worked in San Francisco, and then, actually I don't know if the San Francisco court, I'm familiar with their county. Well, let's use the county. You worked for the San Francisco county for 10 years, and then came here and worked 15 years here. For CalPERS purposes, you have 25 years. For court purposes, you've been here for 15. So no, it's only the time that you've served in the court for the 1,500 per year. And then lastly, does the 1,500 apply for a year of part-time service? No, it's days, it is calculated on days of service to the court. So if you worked half-time for a year, you'd get half year credit for whatever amount of time that you were there. It's a day calculation. Okay, well, that brings us to the end of the question list. I think we got through a lot of those. Is there anything that, oh, there's another one now. This is private. If we take the VSIP option before 50, how do we apply for retirement at 50? Okay, so assuming you are vested, you have to be vested. You would alert CalPERS of your plan, but not get the benefit, right? Then at 50, tell CalPERS that you're exercising your payment option for the 50. But you do want to call CalPERS and make sure to have that conversation with them, but it is possible.
Also, for that person, they're probably going to lose retiree health.
Yes.
So
That's
that
also
should be a
correct.
bigger.
If they're vested in retiree health.
Yeah.
Yeah. Okay, well, is there anything that the CAC wanted to add in closing, or if there are any closing questions, this is the time to pop it.
I think later on, some people might have questions that come up. So you could always email us. We're here to answer questions. So feel free to reach out to us if any questions come up later on that were not brought up today.
Absolutely. And actually, this is I see two more questions privately. Again, folks, if you can, try to ask the questions to everyone so folks can read it. I'll read them and answer them. And this reminded me, if you retire, you are not placed on a reemployment list as you would be if you were laid off. So don't think that you can retire. I just want everyone to do this with their eyes open, right? If you choose to separate from the court, you do not have reemployment rights at the court. So if you leave and you were whatever, a court manager, excuse me, and you're hoping that the budget gets better in a year or two and they'll hire court managers again, you do not have employment rights to those positions. Sure, you can apply like anybody else out there, but you would not have a claim on those. So I got 3 private messages here. I'm going to cut it off here. I'm going to answer these 3, and then I appreciate everyone's kind attention for staying on so long after. Can you speak to the court's expectation with regard to reduction in services related to this furlough? Absolutely. The court and executive leadership was very clear that they expect a decrease in services to the public. They know that this is a big hit. They know that we're taking a 10% plus hit to our budget, and they know that we're going to be losing people's 10% minimum of people through furloughs, right? And then some percentage of the people will retire. So there will be a hit to court services. And I apologize to each and every one of you, and I apologize to every resident of the county, because we're just going to be doing less court services. That's the bottom line. We're going to be doing less court services and less access to justice, which is a disappointment, probably to all of us.
Zeb, this is Demetra. Can you hear me?
Yes, welcome.
Could you also remind our membership about the work furlough, do not work, do not answer your phones, etc.?
I think you just did, and that's right. When you are on furlough, you are off. You are not. Don't even if you have an on-call assignment normally, don't pick up your on-call. Don't pick up your phone. Don't answer your emails. You are off. And
we want to know
very clear.
And we want to know who is calling you if you do get a call, who is emailing if you are getting these things. We need to know. This is basically our membership that might be doing it, and we just need to set people straight.
Yep, absolutely. Be sure to alert us immediately. And it's a reminder to us all. You know, don't reach out to people now. Everybody probably feel some kind of professional obligation to your peers. Be reasonable about this. It doesn't mean you have to throw your phone out the window or something. It's okay if you want. I recommend you don't, but it's okay if you say, I know you're going to have to send me a text about XYZ. Yeah, the thing's in my desk drawer. Fine. You don't have to be rude about it, but the expectation is you don't have any obligation to do that. So my recommendation is let people know you're unavailable and turn off your phone. Right.
And the same applies, Zeb, to long-term leave, but the language is actually even a little stronger because we called out you were not expected to perform court work, and that applied also to ready pay.
Yep, that's correct. Okay, the last two things. Typically, when you leave court and come back, your years of service restart at 0 years of service. I'm not sure that's accurate. I believe that if the leave is less than 2 or it might be 5 years, you resume your prior years of service. And you certainly do if you're out on the reemployment list. If you're out on a reemployment list, even if you're gone for 1 or 2 years, the maximum time that reemployment list, and you come back, you resume your old seniority and years of service for sure. Oh, this person's correcting me and saying not at court. You have to if you're on a reemployment list. That's your right. Perhaps not. I'd like to talk to you more about that because if you're in HR or something, I want to be accurate in what I'm reporting. But I believe we have some contract language about that. But yeah, I'm happy to talk to you further offline. In the event that Skippy does not agree to furloughs, how many positions are they looking to lay off? Approximately 10% of their membership. So how many Skippy people are there? Or 350 or something? Does that sound right? I don't know.
I think it's like 400, low fours, something like that.
So yeah, so 10% of their membership. So you're looking about 40 people, somewhere in that neighborhood anyway. So it would be a pretty serious hit, not only to the Skippy membership, but of course, you know, we're going to have to do without those bodies, which that service to the public. So. Okay, well, thank you all so much. And I want to express my deep appreciation to our SEIU brothers and sisters, and of course you all for not only filling out in a very timely way the bargaining survey, but also to your wonderful CAC. Alex, Laura, Steve, Demetra, Ravi, and Georgia, thank you very much. I don't think we could have done this without you. Nobody likes concessions. Nobody likes budgetary woes. But I think this is a really quality agreement compared to the court saying 20-day notice. Guess what, everybody? We're laying off 20% of the unit. Anything CAC you wanted to say in closing?
No,
okay.
Just thank you, Zeb. We appreciate you.
Thank you, Laura.
Thanks so much.
I appreciate it.
Thank you, Zeb.
Okay, well, I'm going to end it now. As I mentioned, this is recorded. We will be uploading this tomorrow, and it will go out in the e-blast. So you'll be able to access this if you have colleagues that were unable to attend today. Okay, thank you all for your kind attention.
Thank you.
Be safe. Have a wonderful evening. Bye.
Thank you.
Thank you.
Thank you.